Hello, and welcome to our Boardroom Risk webinar. This is a very timely topic with so many norms changing in light of growing geopolitical tensions, the divergence of DE&I landscapes between the US, UK, and Europe, hybrid working, Gen Z, what they want from the workplace, and not to mention tariffs and the recent stock market turmoil that we've seen the last week. So uncertainty abounds, and with uncertainty obviously comes risk, and so there's lots to trip businesses up and their executives as they navigate towards today's rapidly changing risk environment. Which is why I'm particularly delighted to introduce you to our expert panel of risk and resilience specialists. So with that, I will introduce our panelists today. So we've got James Rizzo, who is our US D&O product leader and a specialist exec risk underwriter. He'll be giving his perspective on the risk landscape and for firms and their executives. We've got Kerry Duffel, who is our claims focus group leader for D&O. She heads up our D&O claims team, and she will give her insights into the claims legal landscape amongst other things. And then we've got Harry Ruglan, who is CEO of Crisis Risk Strategies and is an expert in helping firms manage their way through crises. And he will be discussing some of the risks that create crisis and give them his insights on how businesses can try and prepare for the unexpected. And I'm Charlie Evans, the moderator for today's session, and I'm standing in for Kelly Webster, who is unable to be with us today due to some unforeseen circumstances. So as a way of bit of back information, each year we undertake a survey which we call Risk and Resilience. It now covers 3,500 business executives with a responsibility or involvement in insurance buying or risk management within their firm. And the firms are all based in the US, Canada, UK, France, Germany, Spain, and Singapore. And the sample is drawn from a wide range of company sizes and industries. And we ask them to rank their concern and perceived resilience to 4 categories of risk. And the results of the boardroom category that we're focusing on today is what we're going to be looking at. So with that in mind, before we dive into the panel discussion, which I'm sure you're all anxious to get into, we thought we'd take a quick poll to see if you can guess one of the report's findings. Sophie, if you can launch the poll, thank you. So what percentage of global business leaders ranked employer risk as their top risk? 10%, 24%, or 54%? So if you can get starting now with your poll answers, that would be great. Well, it looks like C has won it with 60%. Unfortunately, it's changing now, back again. So now to 43%. Well, the actual answer is 24%, which is extraordinarily low when you think how there are so many risks facing employers today. So with that, let's start the conversation. So to start with, this is a question for all the presenters really, but maybe Harry, we'll start with you first. Just to set the context, what does the phrase employer risk mean to you? And are you surprised that only 24% or just a quarter of executives surveyed rank employer risk as their top boardroom concern today?
I really am surprised because personally, I believe that employee and employer-related risk is probably the most important topic that for most executives, boards of directors, because your employees are probably your most critical asset. And most of the issues or problems that you're going to have emanate from that particular area. So I think one of the things that's probably happening in that survey is that most of us take our employees for granted. We think we know them. We think we understand what their issues are. We don't recognize the fact that a certain percentage, somewhere between 20 and 30% of our employees are coming to work every day with some kind of underlying condition, whether that be drug, alcohol, spousal problems, financial problems, whatever they may be. And those issues contribute to what all of our other corporate issues are. So keeping good employees, training good employees, that's a never-ending process that all of our organizations go through. And I think that we sort of push that off to the side when we're faced with all of, as you, Charlie, were just saying, this incredibly difficult landscape that we're trying to navigate right now with the tariffs and things constantly changing. I think that we push our employee and employer-related risk to the back burner because we think we've got it under control. But I'm not sure that that's correct.
Thank you. That was I completely agree. And Kerry, what's your thoughts on this from a claims perspective?
Yeah, so I mean, I would second everything that Harry just said. You know, from a claims perspective, and after recently managing a book of business comprised of about 80% of EPL matters, I saw significant increase in volume and severity in this space in the last few years. So I was really surprised actually to see that less than 25% ranked it as their top risk. You know, we've been seeing an uptick in race, gender, and age discrimination claims in the last few years, and I'm not really expecting a slowdown going forward, although I anticipate the types of claims in the EPL space may look a little bit different going forward than they have in the past few years, but we'll discuss that later in the presentation.
And Jim, have you got any thoughts on this from an underwriting perspective?
Yeah, I definitely agree that the percent seems drastically understated. Not only exposures that Kerry and Harry touched on, but employment risk reaches into your whole operational side of your house, your ability to hire and retain talent, the availability of skilled labor, as the trades have less enthusiasm by a newer generation of workers, the threat of automation, and then just your employee behavior itself, not to mention the myriad of concerns that come with the intersection of employees and technology when you deal with remote working and how employees are communicating, legal considerations of that. You can't have employees, doing trade orders on WhatsApp, and the general work-life balance of, constantly being in touch with your employer through emails, through the wee hours of the night, and how that affects an hourly versus a salaried employee. There's so many things to be considered of from an employment risk perspective that, again, that number has to be understated and just really not recognizing the full value of these exposures.
No, I agree, and we certainly saw that when we first did the research. But the good news is it is rising. So I think on the whole, business leaders are beginning to take this more seriously, but perhaps not as much as they should be. So let's move on to another question. And thinking about technology, let's just touch on AI and employer risk, because obviously that's a major thing at the moment and on a lot of companies on radar at the moment. And part of our survey, we asked how firms were feeling about AI and job losses in their company, and 69% of North American firms surveyed strongly or somewhat agreed that AI will lead to job losses in their company within the next 18 months. So Jim, what are your thoughts on that?
The opposite of the other stat, I think 69% is bold, because I think the speed of adoption will be slower than people anticipate. But AI is potentially a major disruptor to the employment landscape. And in the same way that the internet disabled brick and mortar, certain industry classes will see a dramatic shift in resourcing. I foresee it initially hitting repetitive functions that can be easily automated. Call centers, customer service, and those type of engagements will rely on fewer humans and go through more of an AI-based system, as well as light-duty legal services that are more fill-in-the-blank contract management type things. I think skilled labor is likely to be protected for some time until the cost of automation comes down, but eventually that'll even see some displacement. We've seen that in the logistics industry already, and there will be haves and have-nots. As tech and humanity intersect, there are lots of considerations: safety, privacy, employee monitoring, the industrial disruption, enablers of new types of competition, not to mention plagiarism and IP considerations when your employees are using these resources out on the internet. And, a failure to adapt will lead to potential loss of competitive advantage. And that's on top of the AI washing and the overrepresenting of a perceived benefit, or the loss of efficiency or efficacy or competitive advantage. There's a lot there, and AI is a major disruptor that we're only seeing the tip of.
Yeah, I think it's going to change all our lives. Harry, any thoughts you've got from your perspective?
Well, first of all, wow. I mean, listen to all the things that Jim just covered. I mean, you could do multiple webinars on just the topics that he was just going through. I mean, we are faced with such an amazing amount of technological change. A few minutes ago, Jim mentioned WhatsApp. For older employees like myself, some of these new technological things, which that's not really that technological, have not even been digested yet. And things are coming every day, new things. And I think the biggest risk that my organization, my organization does a lot of vulnerability and threat analysis and assists, whether it be universities, hospital systems, corporations, in understanding the vulnerabilities and threats that face them. And I think listening to what Jim was saying, it only amplified in my mind what we view as the biggest threat, which is rate of change. It's all of these things combining together, not understanding what AI is doing to not only your workforce, but your customers and the way in which your competitors are coming after you. And when you combine those with all the new technological communications things like a WhatsApp or something else, it's very hard for any organization to digest. And I believe every board of directors, when you're talking about directors and officers of insurance or anything else, needs to understand that having technologically capable people on your board and as advisors, I think is absolutely essential, and it needs to be talked about on a very regular basis.
Yeah. And Carrie, just from your perspective, are we seeing any claims or sort of problems coming through yet?
Yeah, I mean, I would echo everything that Jim and Harry just said. I mean, I think the key is you don't have to be a tech company to be worried about AI, right? It's in everybody's businesses these days. For example, we've seen some recent securities and derivative matters involving publicly traded companies that use AI in their business. Like, think of it maybe embedded in their software that helps, predict algorithms and, statistics going forward. So, a typical fact pattern that we see is where companies overstate the role of AI in their business, which, Jim referenced, which we refer to as AI washing, can lead to alleged misstatements regarding, expected growth and earnings. And then ultimately, when investors learn that the AI capabilities weren't as promising as they were anticipating, we do see fallout in the form of a securities class action. As reliance upon AI increases, I expect we'll probably see more securities class action in this space involving AI. In addition, I think, AI recruitment tools and screening and employment could lead to employment practices matters, litigation, alleging discrimination and bias in the hiring process or in the workplace in general. And, I think I'd be remiss to note, AI can bankrupt companies, kind of to Jim's point, and lead to job loss. And, for example, one of the cases I always think about was during COVID, there was a huge increase in homeschooling and the use of online tutoring, right? Because who could really teach their kids algebra at this point? But, those demands for tutoring rose significantly during COVID, and so did the value of the companies in that space. But after a few months of Chat GPT coming through, the revenue declined, many were left without jobs, companies are going bankrupt. And, as a mom of a high school senior, for better or for worse, the reliance on Chat GPT is really helpful with homework, and it's pretty significant these days.
Yeah, I was a bit worried about my kids, how they're going to do their grades. I think it's thanks to ChatGPT is what they're getting them. So in addition to the rapidly changing tech environment, what else should employers be thinking about at the moment? So maybe back to you, Kerry, on this one.
Yeah, another thing, I think that pops into my mind all the time now is DEI, right? It's really not just a significant employment practices liability risk anymore. We've seen D&O exposure and fiduciary exposure in this case, both in the pro-DEI and anti-DEI space. To be honest, I think it's pretty hard to keep up these days, but note that the change in direction in DEI under the new administration certainly creates risk for companies. A few days into Trump's presidency, he issued an executive order ending DEI programs and practices across the federal government and instructed U.S. agencies to encourage the private sector to also end illegal discrimination and preferences, including DEI. So I think we see companies still trying to figure out their efforts in this space. And, quite honestly, right now, responses are all over the map. I was doing a little prep work for this session. And yesterday, and again, things can change, but yesterday I was looking to see which companies these days are, so-called pro-DEI companies, just a list of a few: Costco, Apple, Lush, the NFL, and Delta. All of them have announced plans to keep their DEI programs for now. The FCC is investigating Comcast's DEI practices as the agency's new chair is concerned about the company's continued DEI efforts, that they don't comply with the FCC regulations. And then on the flip side, We've got companies doubling down and scaling back on DEI initiatives like Ford, Harley, Walmart, Disney, Pepsi, and PBS. We've seen Goldman drop their requirement in the DEI space for IPO companies. Their boards with DEI needed to have 2 diverse members on the board, one of whom had to be a woman. We've seen that been rolled back pretty recently. And, from a claims perspective, we're seeing exposure on both sides, right? I was trying to think of an example, but I think this one helps illustrate exactly what we are seeing in this space. You'll probably all be familiar with a major retail company that's involved in protracted litigation right now, involving a pro-DEI pride campaign in 2023, which caused customer backlash and sales to fall for the first time in 6 years, allegedly leading to over $20 billion in losses. Not surprisingly, we saw a securities class action arise from that fact pattern. And now fast forward, a couple of years, very recently, the same company announced it was going to conclude its 3-year DEI goals. It was going to take back the hiring and promotional goals that it had set for minorities and taking away programs designed to help its Black employees. So now in response, I think you've seen it all over the news, it's facing boycotts and encouragement from many on social media to go to other stores that, continue to support DEI efforts. And they're now dealing with litigation on that front. They've been accused of defrauding their shareholders about the risks of corporate DEI policies. So, we do see it on both sides. In addition, the same company, right? So now they've got lots of litigation against them, and now they've got pension funds coming at them saying that, their position on DEI has harmed the funds that have investments in their company. So I think we're going to see DEI as part of a new and growing litigation trend that's really going to affect businesses across the board, regardless of what their stance is. And again, I'm expecting to see more exposure in DNO, EPL, and fiduciary space coming out of DEI efforts as we move forward.
Yeah, there's a lot going on there, a lot to unwrap. So Harry, maybe you should chip in here and give us some sort of insights in terms of what's going to trip companies up.
Well, I'm just amazed listening to what Carrie was saying, because you think about DEI and you think about the centuries and decades that it took to get to where we just recently were in terms of equality and supporting our employees and doing all of these things. And now DEI is being used as a weapon. It's being used as a tool. And it's hard, again, going back to that issue of rate of change. You talk about boards who just recently were being told you need to have women on your board, you need to have people of color on your board, you need to be doing these things. And now it's whipsawing in the absolute opposite direction. And anytime an organization takes a public position, they're running the risk that they're alienating, unfortunately in the United States right now, 50% of the public. You can't take a position one way or the other. And of course, you've got shareholders who fall on both sides of the spectrum. So regardless of what your political position might be on DEI, it's a very difficult situation for officers and directors to be in. And I think it's more important than ever that they be documenting the reasons that they make these shifts. So unfortunately, when the current administration made the announcements that it did about DEI, a lot of corporations followed and of course had very unfortunate market events as a result of it. And we're going to see that, I think Carrie's right, coming through in litigation currently. So I think, the business judgment rule really protects a lot of the decisions that officers and directors make. But I think it's becoming more and more important that those decisions be really carefully thought out and don't move quickly, because I think as we've seen with the recent tariffs, it's a whipsaw, it's going back and forth and back and forth. So when you make a decision or you make an announcement that affects the brand and reputation, not only of just your organization, but of the people in your organization, you need to do that very carefully. And I think a bit of pulling back on the reins, taking your time, making those decisions carefully. You don't need to make them quickly because, again, you don't know, next week it could be something entirely different.
No, I can see it's very tough for these companies to decide which way to go. And Jim, from an underwriting perspective, what's your thoughts on this?
Well, I can tell you it's a wonderful time to be a D&O underwriter. It's a very friendly climate for us. From an underwriting perspective, touching on what Harry said, we'd like to see a company take a tempered approach to this. We like to make sure that our boards are proactively reviewing their policies and staying abreast of the changing landscape. But when they make the change, we want to make sure that it's in a methodical way. And it's not just DEI. It's insurance loves its acronyms, but as a part of the AI, DEI alphabet soup, we have ESG. And we want to make sure that those companies are setting goals that are achievable and make sense with their nature of operations. If you're an oil and gas company, you're not going to be carbon neutral. It's nearly impossible. And if you're setting these carbon neutrality goals, good luck getting there. That's a red flag to me as an underwriter because it's really not essential to your nature of ops. We want to see companies that are promoting economic and social prosperity and treating customers and employees fairly, but we also want to see a balanced look at what they do and the characteristics of their goals. As far as the board quality, we do like to see a mix of tenure and diversity, gender backgrounds, people that have an acumen in the industry, as well as good financial backing and other characteristics. But there's a lot for our corporate leaders to pay attention to, and there's a lot for us as underwriters to pay attention to.
Yeah, I can believe that. And so, just sort of segueing a bit, how do you think the changes in the EEOC may impact boardroom risk exposure? And Carrie, it's probably one for you to answer.
Yeah, sure. I think that probably everybody on this call knows, what the EEOC does, but just background information. The EEOC is charged with enforcing and setting policy agenda with respect to federal anti-discrimination laws, and they've got authority over almost all employers. The EEOC enforces and sets policy agenda. It's bipartisan. It's comprised of 5 commissioners that are appointed by the president and then confirmed by Senate. The commissioners are really the ones that approve most of the litigation that goes forward, and they make decisions regarding policy issues, and they serve for 5-year terms. And interestingly, no more than 3 can be from the same political party. So as we've seen and discussed, the new administration is moving rapidly, making a lot of changes. So right now, there are only 2 current commissioners, no new Senate confirmed appointees. So right now, the EEOC is not really able to issue new regulations and advance enforcement actions and issue legal guidance. But perhaps I think most importantly from our perspective here, at least from mine, as we just discussed, Trump issued an executive order to end DEI and affirmative action plans. And so the administration has also implemented changes to policies and practices related to gender identity and sex. So now these days it's male or female only. So do you think we'll see some claims and litigation in this space? I think the current chair has stated that she plans to focus on protecting American workers from anti-American national origin discrimination and defending gender identity, including the woman's rights to single-sex spaces. She's also planning to focus on protecting workers from religious bias and harassment and remedying other areas that have been historically under-enforced by the agency. So, I think in sum, we've got a new administration and a new EEOC that aligns with the president's policies, especially with respect to gender identity. Just noteworthy, I think, over the last few days, I saw an article that gender ideology materials were removed from the EEOC's website, and, reference to any type of pronouns were also deleted from profiles. So do you think we'll see litigation in the space going forward? But I expect the EEOC's focus to look very different than in the past. And boards really need to be proactive to comply with the EEOC guidelines to mitigate the risk and to help navigate the evolving regulatory landscape. They need to ensure compliance with EEOC directives in order to avoid legal challenges. I think employers are going to need to review their, handbooks, their policies to make sure that they actually do comply with the new policies. And even though the focus is different, there are a lot of changes that will need to be made by companies to comply with the new EEOC guidance going forward.
Yeah, Jim, what are your thoughts on this?
It's amazing everything that Terry said, because it is such a dynamic environment, and we've really never seen things move at this speed. Historically, the EEOC has not been quick to adapt the winds of a changing party. Historically, there have not been immediate changes to websites and a complete revamping, but now you'll see that all the federal websites have adopted this new vernacular. And now it's already reaching down into the states. I think we're setting the stage for a climate right for a wave of reverse discrimination claims. And I think that's something that employers should be keen on preventing and being ahead of. To me, that's the biggest concern out of this whipsaw that we're seeing.
And Harry, I'm sure you're going to be busy at crisis risk with all of this, but what's your thoughts?
It's hard to digest. How does a corporation respond to these situations where for the last X number of decades, they've been building an equality system within their organization where they're protecting their people from any kind of discrimination. And then you have an administration that comes in and uses executive orders in a way that they've never been used before. And whether you agree with what they're doing or not, they're changing things at such a rapid rate that all of the rules, you literally can take the EEOC rule book and throw it out, and you're going to be expected to conform to a new one that hasn't even really been finalized yet. And don't forget, just because you change on the executive side, you come down with an executive order, that doesn't mean that the courts have changed necessarily. So it depends on what type of judge you get in front of, what kind of juries you have. I mean, it is a very uncertain landscape for corporations, and no officer or director should be making assumptions about how the EEOC affects them or their organization today based on what might have existed yesterday. So literally, the exposures have changed overnight. And going back to what Jim was saying, taking that measured approach, everything right now needs to be done carefully and slowly, because the rules, we don't understand what the playing field looks like at this point. And that takes a lot of patience, and it's going to be interesting to see how it develops.
Certainly a minefield. I think, Kerry, should we just talk a bit more about reverse discrimination, which Jim mentioned just now? I think that's a very interesting.
I was going to say, Jim not came up with it, but he hinted on it. And I do think that we are already seeing an increase in reverse discrimination claims. So I think people know what they are, but they're claims that involve individuals from majority groups alleging discrimination based on race or sex, sexual orientation, and orientation. Changes under the new administration targeting DEI programs have led to increased scrutiny and legal challenges and are contributing to the surge in reverse discrimination claims. I think we all know a well-known fast food chain that just very recently was sued by a group opposing affirmative action over its scholarship program for Latino students. That program had awarded over $33 million in scholarships to over 20,000 students. It was recently alleged that the program used race and ethnicity as a factor to determine, who was going to get these scholarships. And it was a requirement to apply for this scholarship that you had at least one parent of Hispanic heritage. This flash forward, it's been settled very recently, and it's now open to any student who demonstrates a meaningful commitment to the Latino community. You don't have to just have one Latino parent anymore. It's open to everybody. So I think that's just one example that I saw in the news the last few days. Another one comes to mind, actually, was a case I worked on that involved a white male executive, senior vice president of a marketing communications company at a healthcare system in North Carolina. He filed suit alleging he was fired due to sex and race. He claimed he was fired so the company could replace him with a female to help further diversify to meet its diversity goals. The matter went to trial, and the jury awarded over $10 million in punitive damages and back and front pay. So I think that for the first time, at least that I've seen since I've been working here, was a very significant jury award in the reverse discrimination space. The case made its way to the Fourth Circuit, and the punitive award was knocked down to a much smaller statutory amount, but the Court of Appeals did hold that he was entitled to back and front pay. So, I do think that we have seen, I saw another coffee chain has been sued by a white male again last week, trying, I guess, a reverse discrimination case in that context. And then I feel like I'd be remiss maybe to not touch on at least the Ames case, which is currently pending before the Supreme Court. There we see a white, straight female claiming that she lost out on a promotion and was demoted because she's straight. She alleged that a lesbian woman was hired for the promotion instead of her, and that she was then demoted and replaced by a gay male. The Sixth Circuit threw out her sexual orientation claim and said because she was straight, she had to show background circumstances to support her allegations of reverse discrimination. So the background circumstances was a little bit high, it's a higher bar. If it was a typical discrimination case brought by a minority person. So essentially the appeals court was requiring a higher standard to bring a discrimination claim because Ames was straight. The matter went up to the Supreme Court and was recently argued in January. Ames asserted that the federal employment discrimination laws are supposed to eradicate all discrimination in the workplace, and requiring members of the majority to show background circumstances actually perpetuates discrimination. Notably, everything I'm reading, it's expected that the Supreme Court is going to overturn the Sixth Circuit's higher bar requiring background circumstances in this instance. And I think that this shift could influence future claims in this space and may, in fact, open the floodgates for more reverse discrimination cases, as we move forward.
Gosh, it's a frightening landscape, how that really is. So how can employers be vigilant and about potential reverse discrimination claims? And what can they do, especially as we've mentioned, when they want to continue implementing DE&I initiatives? Jim?
As Harry mentioned, I would start by treading carefully. Actions can be very polarizing, and the reality is in this world, you don't have to be guilty to suffer litigation. Most cases settle without, even those without merit, just to avoid defense costs, reputation risk, and negative publicity. But getting back to your question, while shareholders measure companies by profit and growth, employers should be certain they're striking a balance between their business objectives and creating an environment that's fair and with opportunity, an opportunity for everyone, not just a particular race, creed, gender, preference, or any. Just create a meritocracy that can feed the diversity of humans into the mix and let people compete fairly. But any drastic change in posture is going to raise eyebrows and involve scrutiny, not just by investors, but by customers. The reality is we have this challenge of the social pendulum that really swings like a wrecking ball. It creates an environment of uncertainty, and our corporate leaders need to be tempered in their approach and guided by the advice of their counsel, their brokers, their carrier partners to ensure that their DEI programs comply with the current legal environment and standards. You don't want to inadvertently discriminate, and you just have to be careful to protect the minority and the majority. So have your counsel at the ready to navigate the changing landscape because it's dynamic.
And that brings us on neatly to thinking about reputational risk, which I know is, fundamental to businesses. Really, there's so much value in reputation, and once it's been lost, it's very hard to get it back. So, Jim, are there any specific areas where companies should be concerned about reputational risk linked to what we've been talking to?
Well, I'm tired of all the doom and gloom, but the reality is reputation risk hides in every corner. Information flies fast, and our citizens enjoy being outraged. It's an interesting time in that workplaces and juries are now populated with 4 generations of highly divergent ideology and experienced people. So, we have this workplace that ranges from baby boomers to Gen Z, and they don't always see eye to eye. They don't always think the same. And there's definitely a different leaning in the dynamic. So it's a loaded space. And the younger generation, the Gen X's and Gen Z's and Gen Y's are are all internet enabled and activist minded. We're seeing violence, vandalism, and opposition against corporations be celebrated in the media. We saw a major health insurance provider suffer a violent loss, and people were cheering and making a hero out of the actor. You're seeing retail boycotts just for the change of the tide and trying to adjust their posture relative to a macro environment. It's tough, but any action or change in posture can be deemed as polarizing. And it's not just DEI or not DEI, it's environmental matters. It's food quality and product safety. It's your political leaning. It's your support. It's your PAC activity. It's the human behavior. It only takes one bad actor in your workforce to create reputational risk, or the non-human behavior of deep fakes and things that are happening on the internet. Even memes that misbrand your company have reputational risk and harm. So, I would be prepared for a crisis, and when dealing with crisis, make sure that you have the boilerplate and the steps for the appropriate handling, because your corporate response is essential, and the way you manage that is essential. Mishandling of it can not only generate a response much larger than the initial catalyst, but also lead to securities class action and prolong that negative social media cycle. So engage your experts.
And I think,
Harry.
You mentioned it, Jim, but I think the sort of anti-corporate sentiment is something we should probably touch on. And Kerry, how's that impacting sort of verdicts and in these cases that are coming to court?
Yeah, so I mean, I don't want to cut Harry off if he wanted to chime in a little bit on the reputational risks, but I'm happy to dive into what we've been seeing. I think since post-COVID, we've seen increased verdicts, what we refer to as nuclear verdicts, anything over $10 million. We have seen an anti-corporate sentiment towards, all types of corporations, including healthcare systems, who we had hoped would be viewed, as, helpful during the pandemic, helped save humanity. That's not at all the case. I think people are really angry. I think this goes to what Jim had said earlier, but there are biases towards, I would say, current jurors go in feeling like they're going to side with plaintiffs, just generally. That's kind of like the gut feel. I think that's a change in what we have seen, pre-pandemic, the social inflation that we're seeing. So the increased costs of settlements or the amounts that are awarded by juries. When I mentioned the $10 million punitive verdict in the reverse discrimination case, I mean, that was definitely a significant change in what we would have seen, I think, pre-pandemic. But we are seeing additional concerns. I think with some of the younger generations, don't always see eye to eye. I think with, some of the older generations like Gen X or baby boomers. So it is a very interesting time to send a case to a jury, I would say, right now.
Yeah, and I think that, I'm talking about Gen Z, that brings us on very nicely to thinking about social media and how, any misstep can be magnified in seconds, and just at the click of a mouse, things can go viral, as we've seen. So, Harry, from your perspective, how can companies try and control the narrative and even prepare for this risk? If they can't control the narrative, what do they do?
Well, it's interesting. Social media is a quagmire for most organizations to some degree because of the multi-generational aspect of our workforce. Baby boomers like myself approach social media completely differently. So, when Jim mentioned a minute ago, the idea of having experts that you go to beforehand to help you in your planning, your training, your education, that's so essential now. And it's essential on issues of technology, and that includes things like social media, because whether you like it or not, the majority of your employees, your customers, everyone else, their parents, their children, they're all on social media every day. And it's really important to understand what's being said about your organization, what's being said about your people. What is your view of your corporate image the same as what's being said out there on social media. Corporations and organizations take a lot of risk with their brand and reputation. They have a lot of problems every day because, as you mentioned, things get out there on social media, they can go viral very, very quickly. And if you don't know what's going on, some of the damage is irreparable. Because even if you go out and try and correct what someone said, you can't correct it in the eyes and in the minds of all of the people that have seen it. So it's being used as an offensive weapon to some degree by competitors and others. So it's really important to understand that your workforce is shifting. The way in which your workforce communicates is shifting. Your customer base is utilizing different tools to analyze your organization, to analyze the way in which your organization behaves in the environment. And going back to what we've been talking about with the divide in the current populace in the United States, half of the people may view what you're doing as right and half may view it as wrong, and there's no easy answer. So you've got to be very moderate and careful in the positions that you take on social media. It's a very difficult and dangerous place to exist right now in that sort of cyber world.
Yeah, it certainly is. So I think we'll just take a break now. We're going to do another poll, but also just to remind everyone who's listening, if you have any questions, do put your questions in the chat, and if we get time at the end, we will try and get to you. We'll get to the questions. So our poll question here is: what percentage of North American executives surveyed believe that changes in the political landscape will affect their ability to trade profitably? So it's quite a split. Oh, look, we've got a split between B and C. Well, the actual answer is, B's winning. Okay, well, I'm going to take poll as the fact that you're actually wrong. It is C. It's 71%. So that's a high degree of people who do think that political landscape is going to affect their ability to trade profitably, which what we're seeing at the moment is perhaps no surprise because there's so much uncertainty, as we've already mentioned. So let's move on now and think about geopolitical risk, that segue. But with geopolitical risk, we're experiencing at the moment, and obviously it's escalating. So how is that actually translating into additional risk for insureds? We've got tariff wars that are here. We've seen supply chains emerge like we did in the pandemic. We know that supply chains are likely to be impacted by what's happening at the moment. And could these, create D&O exposure for boards? And are you anticipating this? And I think, Jim, that's really one for you to start with. Yes,
absolutely, 100%. As per NEAR, the 2024 securities class action trends showed that 41% of claims came out of earnings, and 32% came out of misled future performance. So when you think of this context of a dynamically changing business environment with tariffs and regulation and deregulation and the Trump effect and the Doge effect and domestic inflation, that's a lot for our business leaders to deal with and to contend and to calculate and to forecast and to figure out what their business is going to do forward looking. The fact that companies even give guidance at this point is a surprise to me, but they do. And, the shareholder base sometimes requires that. But the thing to remember is that inflation impacts everyone, the customer and the producer. And so while your customer demand is dropping, your production costs are going up. There's a lot of things to contend with when you're trying to forecast your future. The global instability is absolutely going to lead to supply chain issues. And we saw that during COVID. There were a lot of post-COVID SCAs that dealt with change in demand or inability to meet supply chain demands. It's a difficult thing for companies to deal with because they're either overstocking or they're destocking, and they're dealing with a reactive approach to their business versus the typical proactive environment that they can exist in. Not to mention the impact of immigration controls and what that could potentially do to the agriculture community and industries that highly rely on migrant workers, both documented and undocumented. So agriculture, hospitality, and construction have a whole new set of challenges that they didn't have before. It's we've said it before, it's a very tough time, and there's exposure everywhere, including the geopolitical landscape.
And Harry, let's have your perspective on this. It would be interesting to hear what you have to say.
I'm at a loss for words listening to what Jim was saying. I was the CEO of a publicly traded company once, and I know that the best practices recommendation then was that you be doing a vulnerability and threat analysis once a year and continually updating that. Once a year in today's world, trying to analyze what your vulnerabilities and threats are is just not enough. It would need to be a continuous process at this point, because things are changing so rapidly. And I can't imagine, trying to rely on the business judgment rule to protect me in the litigation, or to stand behind the vulnerability and threat analysis that we did a year ago. Obviously, it wouldn't take into account any of the changes that are happening now with the things that we talked about, whether it be EEOC or DEI or ESG or any of those other, the alphabet soup that Jim was referring to. I think that boards and officers need to be continually looking at the vulnerabilities and threats that face their organization and the way that they're changing day to day. And it is a very daunting and difficult process. I think you need to be utilizing the eyes and the ears of your people, because they are, that's where you're going to get your best information from. How are things changing? What are they hearing from your customers? What are they hearing from your shareholders? And again, it needs to be continuous improvement. You need to be evolving on a very regular basis. And that's not something that most organizations are good at, and that they have a program in place to do. So it's very difficult.
So on that very pessimistic outlook,
not pessimistic. Just I'm overwhelmed listening to it. Because obviously one of the things that I think is wonderful about what Beazley is doing here by bringing these experts to the table, listening to Carrie and Jim. You need continuous update on your information, and you need experts to help you with that. And so I'm learning a lot on this call, on this webinar myself.
And I'm sitting here thinking, if I continue to do a decent job in my role, like, I'm going to need some more people, because I feel like there's a lot of litigation headed to the claims department. That's what I'm sitting here thinking. Wow, this is a little bit of doom and gloom, but I think that is probably the new reality for a little bit until things shake out a bit.
Yeah, and I think the lawyers must be licking their lips with excitement. Anyway, there's a lot for them to do. So we've got just about 10 minutes left. So we've got a couple of questions. So let's start with one. Jim, I'm going to ask you, any changes in the legal and regulatory environment that we haven't discussed that you'd like to think we should highlight?
There are actually two major changes that came from the Supreme Court that I'm surprised we're not hearing more about in this industry, in executive lines especially. The Supreme Court recently overturned the Chevron deference, which I don't know if you know what that means, but that held that federal courts would defer to agency interpretation when faced with an ambiguous statute or law. Supreme Court overturned that and basically said that regulators should not be given special deference to interpret the ambiguous law, and rather left the court as the arbiter of that. Well, that is a big disruption to case law, and it historically came up in environmental matters, but we've seen it applied to other legal. And there's some pros, cons, and unknowns about that. The pros are the insurance, they may benefit from a more favorable venue or jurisdiction or sympathy to an industry. If you think about how this applies to an oil and gas company in Texas, that could be favorable for them. It can protect the businesses from ambiguity in law and rulemaking, which we've seen in the past harm businesses. And it can potentially slow the publication of new regulations, because the regulators will have to be more thoughtful in how those are applied to avoid any regulatory overreach. But the cons, as I mentioned, it's disruptive to case law, and that just makes legal matters more difficult. And it potentially contributes to this environment where the regulator can strong arm with legal system abuse the sort of pay ball or pay more, play ball or pay more. And so we'll have to see how it shakes out. The unknowns really are will the insureds be willing to fight? Are they going to challenge the courts, or are they going to just roll over and take as is? And it's given the disruption to case law, the economics to settle or not to settle, I think, are a whole new thing for Kerry and her team to think about. And we don't really know how qualified are these courts in interpreting the regulatory policy. So that's something to be seen. The other Supreme Court is the recent Purdue decision, which was a recent ruling in the bankruptcy code that doesn't authorize non-consensual third-party releases, except I think for asbestos liabilities in Chapter 11 cases. That overturns a jurisprudence that's prevailed, for decades, and is allowed for the resolve of complex litigation and companies in complex situations. If you think about how companies have historically, with long tail liabilities, have gone through a reorganization and a bankruptcy, they set up a trust to handle these long tail liabilities, and they have a legal moat that's created by this Chapter 11 proceeding. That's now been weakened by this recent overturn. And while there was a rationale for that overturn, it does, it's to be determined how that's going to affect large corporates going forward. And I think it could have significant implications that I would love to hear Kerry and others opine on, because I'm really surprised we haven't heard more chatter about it. And I'll leave it at that.
Great. Okay. So, sorry, Harry.
May I make a comment, please? As a lawyer, I listened to Jim talking about the Chevron decision, and I think it's important to understand the ramification of that, because going back to the whole issue of rate of change and inconsistency and unknowns for board members and officers and directors, what they just did was take away the consistency. It used to be that if there was any question, deference was given to the agency. And that led to consistency from administration to administration. You couldn't have these rapid changes. Now what you've done is essentially say that any judge can make a decision on what agency policy actually meant and how it should be implemented. And it swings, as you can imagine, wildly based on the both political affiliations of the judge, but also just where they are in the country and how they came up through the judicial system. And I mean, it is a really significant change. And I agree that I'm surprised you're not hearing more about it, but the impacts of it, you will be hearing more about, in the coming year.
Okay, so we've got a question here about which is a positive one, is, are there any bright areas ahead for 2025? We've talked about a lot of the issues, but are there any sort of bright sparks on the horizon that we can cling to?
Well, I can certainly talk to one. I mean, the AI one that we discussed, the changes in technology are not just negative. We're seeing very positive capability to reach your customers, to communicate better with your employees, to better improve your products, to know sooner when you need to do recalls. I mean, there's all kinds of very positive things in the marketplace as well as a result of technology, as a result of that rate of change. But again, organizations have to have the process and procedure in place to take advantage of those. And that requires, again, consistent and constant improvement in your process and your training, your education, your communication. So,
yeah, Kerry, anything you had to add?
No, I would agree. I mean, I think we were anticipating, certainly a few months ago, with the new administration, we were expecting a more business-friendly environment. Although everything I've heard today on this call, I'm not sure that that's the case. We were expecting more M&A and the IPO market to come back. I've talked to Jim in preparation for this. I mean, I think we are seeing some glimpses of that, but certainly not where we expected that to be. I mean, I think we'll see regulatory reins loosened a bit, some kind of leniency in corporate and construction and permitting, but it is a little bit difficult, and I think it's a little bit unexpected, I think, the rate of change and how drastically things have changed in the last, 2.5 months or so. But I don't know. I know Jim said he was seeing some new submissions. We were thinking we'd be seeing a flood. Maybe a floodgate is a little bit too strong, but we're seeing a small uptick, I would say, in M&A activity. But maybe Jim can.
Yeah, it changes daily. We did see a minor uptick in IPO and SPAC listing activity, as well as hearing some M&A in the channels. And then recently, a few IPOs have just been shelved and pushed down the road. I think that's just the market volatility in reaction to maybe some of the tariff strategy that's happening. I think it's a wait and see. This script was completely different 4 days ago. It'll probably be completely different in another 5 days. I do think it is a more business-friendly environment in the sense, from a regulatory perspective. Even the overturn of the Chevron deference took a lot of authority out of the regulator. That can be good for business, assuming that they can conduct themselves without undue financial burdens from this inflationary environment and the tariffs and real sourcing challenges and everything else that comes with that.
But I think, Jim, what it did was it took away the stability. And when you're talking about going out and doing an IPO, you need stability, you need predictability. And what's going on in the markets right now, if I was the officer or director of a company that was about to go public, I'd be very uncomfortable with the markets the way that they are, not knowing how that would affect my IPO. It's very uncomfortable.
We come back with the whole uncertainty piece. So we've got 2 minutes left. So I think just in summary, we've heard an awful lot about the sort of multifaceted risks that these firms are facing today, and also the importance of really having active crisis plans. I think, process planning, not making rash decisions are the messages I'm taking away from this today. And I think, when it comes back to D&I, I think we haven't touched on that very much, but I do think the tone from the top is so important. They can set the tone. And I think, once people have a strong culture in a company, that definitely helps. And also the vital role that insurance has to play. I think, I know I would say that because I work for Beazley, but I genuinely think, the risk insight that we can provide as insurers and sort of, and help firms to, to have that financial mitigation they need for these many liabilities that they're clearly facing is going to be increasingly important as, in this era of accelerating risk. So it just takes me to say thank you very much to the panelists for joining us today. It's been fascinating and I've learned an awful lot. And also to the audience for staying with us. I hope you found everyone's insight valuable. And at the end of this, when we come on offline in a minute, you will see that there will be a screen. And please do give your feedback. And also, if you'd like to find out more about us and get to access our report, just click on the link that's up on the screen now. So thank you very much. And I hope you've enjoyed the session.